Thank you for watching this video from the Canada-Europe Transatlantic Dialogue at Carleton University. This event is sponsored by the Canada-Europe Transatlantic Dialogue, CETD, and the Faculty of Public Affairs Research Month at Carleton University. CETD receives funding from the Social Sciences and Humanities Research Council of Canada. The views expressed in this video are solely those of the presenter and do not reflect the views of the CETD, SSHRC, or Carleton University.
Thank you, Armand. I would also like to thank everybody for coming in today to listen to our legal talk about CETA. And certainly to thank Joan and Armand and Kurt for inviting me to be the part of this event. I think that I am scheduled to talk more about the context of CETA and how it actually fits into the Canadian and the world practice in negotiating preferential trade agreements. And I'll use different terms through my talk: free trade agreement, preferential trade agreement, preferential trade and investment agreement, but they all mean the same, that partners are giving themselves preferences beyond what the multilateral trade agreements are requiring them to do. What I'd like to say at the beginning is really that I'm trying to make only 3 points in these 20 minutes. And the first one is really that CETA is a kind of a logical extension of the international economic cooperation model that Canada has adopted since NAFTA. And that NAFTA is the model that both US and Canada have used in negotiating other agreements. So getting into the CETA format of negotiation, Canada is expanding its current practice in negotiating agreements. So that's the first thing. That historically we can see similarities between NAFTA and CETA, and the new areas are something that we see included in other agreements that other countries are negotiating as well. In the current context, and that's probably that's part of my title, Between the Rock and the Hard Place, is that Canada now has really preferential trade and investment agreements with all of its three major trading and investment partners, with European Union, United States, and China as well, right? We have ratified bilateral investment treaty with China. We are also part of TPP, and it's interesting to see what's going to happen to NAFTA once the TPP project really gets underway in a very significant way, as CETA has actually progressed. So whether that would actually mean that we would need to modernize NAFTA or to do something about it, and with other free trade agreements that we have with other partners from TPP countries. So we are in a spaghetti ball, all of us, and I'll talk more about it. Of course, European Union and United States are also negotiating TTIP. And of course, there is this really interesting Chinese initiative, One Belt, One Road, that now emerges not as a kind of a formal mega regional free trade agreement, but in a very interesting way, trying to connect 67 countries on the Silk Road that are all somehow connected with some form of Chinese investments in it. So it's a really interesting time in which this is all happening. And a third point that I want to make is that trade treaties are living organisms. There is a text and that has been negotiated, and at the moment, I think these negotiations are really taking long time, approximately 5 to 7 years for a free trade agreement, a very comprehensive one, to really be negotiated. And to that, you have to add the time of ratification, and depending on how many parties are involved, that all prolongs the time. And what I'm saying that it's a living organism is that no matter how much lawyers prefer certainty and predictability in the text of the agreement, there is an understanding that text can never capture everything that can actually happen in the business world, because trade agreements don't really exist in vacuum. They have to actually facilitate the actual business and mobility of the capital and people and goods and services and investments. So there is always a question after several years how flexible these agreements are and how relevant they are. They're very difficult to renegotiate and to vary and to modify. And there is always that question, how much flexibility is really left in the agreement. So what I'm going to talk a little bit more in the rest of the time that I have available is about that novel chapter, not the one on investment. That's, I think, what Marc is going to be talking more about, but really about regulatory cooperation as some kind of a flexibility. So just to put it into context in numbers, if you go to the WTO website now, you can find information that there are some 625 notifications of different regional trade agreement or preferential trade agreements. And they're counting goods, services, and some accessions separately, not related to investment treaties. We know that there are more than 3,000 investment treaties as well. And out of those 425 that are notified to WTO, 413 are in force. So that's that spaghetti ball of different rules on trade. And at average, every WTO member has at least 13 preferential trade agreements that they're a member of. And if you look into different models of cooperation, you can actually say that there are at least 3 waves internationally of these agreements. That in the early 50s and 60s, of course, you have the European community, European Economic Community being really the leader, the first one that actually seriously challenged the exception in the GATT, Article 24, and the one that actually inspired a lot of regional blocs when they were later considered. I mean, you can look into Andean community that really looked as a kind of a carbon copy of the model, but yet never as successful. You could look into AFTA as a training ground for economic union for a number of countries. You can look into Central American common market as well being influenced. And then, you know, in the 70s, in the 80s and 90s, the countries actually started engaging much more into bilateral negotiations, and the reason for that is some sort of a stalemate at the multilateral level. And again, you see that the European Union really was the leader and creating a lot of free trade agreements with African and Caribbean countries, for example, and in the 90s with Central and Eastern European countries, creating, again, very novel association agreements, very comprehensive, the ones that are preparing really for the accession to the European Union. And it is in that period where you actually see that regulatory cooperation component has become the part of the practice of European Union or the European community even at that time, which you have never seen in other free trade agreements. And where certain models of that cooperation between the regulatory authorities of the countries involved in the trade bloc have actually been regulated. And at the level of European Union, it is really not only the mutual recognition, but even at that bilateral level, at the level of harmonization, because the associated countries needed to harmonize their laws and regulatory practices with the EU. So that's quite fascinating. So basically, I'm giving you some sort of an idea how some of these some of these CETA provisions have actually emerged and evolved from the practice that we see. So it's really interesting to see how people were actually talking about NAFTA versus CETA, and there were Professor Frederick Abbott once said that NAFTA is actually integration without institutions. So it was never meant to last as long as it's been lasting and producing some results. And I guess most people really know about NAFTA by looking into Chapter 11 investment treaties, but there are other chapters where seemingly there were no disputes and there's much more cooperation. So that's kind of an interesting to look into. I don't know how much time I have. Can you just 5 minutes? Okay. So I just want to say a few things about the Canadian practice and EU practice in numbers as well, just to put a kind of a reference. Canada has in force 11 free trade agreements, and it has the 38 FIPAs. It's also negotiating many of them. On the European side, for example, you have at the moment 37 free trade agreements in force, 13 announced, and there are then 52 in force of these other international agreements that are much more complicated. But it is interesting to compare them with the United States, again, because we are really looking into United States as well when we are talking about CETA. We cannot actually forget the impact that can have on NAFTA as well and on our relations with U.S. U.S. has 14 free trade agreements in force, and one just announced, and it has 46 bilateral investment treaties. Now, if you shift to the European Union, you have to look, if you're looking into the numbers of bilateral investment treaties, you actually have to look into the member states, because that's really what's important. Since 2009, it was only since 2009 that the European Union got the power to actually negotiate investment chapters in these agreements. So think about these numbers. So Germany has 135 bilateral investment treaties. France has 104. Now I'm talking about only 6 founding members here. Netherlands 95, Belgium 93, Italy 88, Luxembourg 68, and then UK, which is kind of always trying to make up their mind where they want to be, 106. So I guess Marc is going to talk a little bit about this, what is going to happen with all these agreements, and what is the dispute settlement clause in all of these agreements. I mean, a lot of them have the traditional state investor arbitration. So that's going to be something to think about. What is really specific to CETA model? That chapters are reaching into regulatory areas quite a lot, even when they look like a traditional one. TBT goes beyond NAFTA chapter on technical barriers to trade, goes beyond NAFTA and beyond WTO. So we're talking about WTO plus elements, SPS or sanitary and phytosanitary standards as well. You have trade labor mobility, which goes beyond NAFTA, because in NAFTA that was kind of a side agreement. Then you have a first chapter on regulatory cooperation, first chapter on sustainable development, first real chapter on environment in FTA as well. So we are kind of breaking a new ground in many areas here. Yet, we talk about CETA as being also modification of a free trade agreement. So now fast forward to that regulatory chapter, and that's a really interesting one. Just to say what really this regulatory chapters do? What is it about? How do we define regulatory cooperation? OECD is defining it as a range of institutional and procedural frameworks within which national governments and regulatory governments work with the wider civil society to build a rule-making system that is based really on transparent, accountable, and responsive governance, government and governance that still has its sovereign regulatory sovereignty to some extent. And I guess if you look into the regulatory cooperation chapter, you'll see that there is a forum as an institution that brings together national authorities to actually discuss the modes of cooperation. And cooperation at this level is incredibly important because the regulatory divergence really raises production costs and limits market access. And for that reason, kind of a coordinating at the level of national and subnational provincial governments at that regulatory level, increasing transparency, providing the possibility to comment on certain proposals would eventually increase productivity and employment and would help to attract investments. What's really interesting to see here is that when you look into the regulatory cooperation at the European Union level, the big question here really is the one of the objectives, right? And the objective is really to contribute to the protection of the human life, health, and safety, and environment. So that's at the core of regulatory cooperation. And for European Union, the most important principle that actually contributes to that protection is the precautionary principle. So you can't really find it in CETA. So that's the kind of a balancing act, I guess, as well. You are really agreeing on the models of mutual recognition and some sort of a assessment, conformity assessment models of agencies, but there is no precautionary principle there that's really dear to European Union, whereas Canada is more kind of a leaning towards the WTO science-based model when defining these regulatory objectives. So I guess you have to look into this agreement as something new being added, but also actually building on the practice of the both sides. And keep in mind, again, that this is going to be the living agreement, and sometimes in practice, those provisions that we think that are the most controversial may not be in this particular set of circumstances most controversial. And we had a little chat before this panel started on Canadian experience, for example, with investor state arbitration. And we said, well, NAFTA model has been replicated in all Canadian FIPAs. And we didn't end up with any disputes except for NAFTA Chapter 11. So there are no any other disputes with any other countries coming out of these agreements. So that being said, I guess that this is really an exciting moment for Canada and for European Union, testing some new ground and definitely considering how seminal NAFTA was and previous models of economic cooperation and integration that especially European Union has actually offered. I think it's expected that this one also be quite important and followed by others. Thank you.